Well, hi everyone, and welcome once again to our Feeling Smarter weekly series. As always, I'm joined by my co-host, Tim Miller. G'day, Tim. How are you?
Yeah, going pretty well, Aaron. How are you doing?
Not too bad, thank you. Well, last week we broached the subject of trustee structuring, and we looked at single member funds and what we need to do to adhere to the definition within 17A. And that obviously borne out a few more ideas that we thought would be appropriate around alternate trustee arrangements. So we know that 17A kind of requires that joint ownership inside the fund. All members must be trustees or directors and vice versa. But that's not where things ultimately have to land. And I might get you, therefore, to elaborate where some of these other alternate arrangements come about.
Yeah, so this is typical of SIS, and it's one of those tricky little bits of legislation where it pretty much prohibits or restricts everything, and then it chucks in exceptions, and so it tells you this is the definition of a self-managed super fund, except when, right? And so we have the primary exceptions, and one being when a member passes away, because clearly when a member passes away, they can no longer act as trustee of the fund. But then it talks through the concept of legal disability, right? So that legal disability might be incapacity, and it might also be based on age. And then we have a third alternate where you have the opportunity where, via the use of enduring powers of attorney, that attorney is appointed in place of the member to act as trustee of the fund. So you put these three scenarios together, and it basically provides for a number of opportunities where the membership and the trusteeship of a self-managed super fund won't necessarily align, but the fund itself will still satisfy the definition of a self-managed super fund.
Yeah, and that last one is clearly going to be the one that is becoming more and more of a discussion as we've got older Australians continuing with their self-managed funds. If we go back to the early stages of our SMSF careers, the age demographic in the SMSF sector was probably, from sort of the 50-ish mark, late 40s, maybe through to the 70s or so forth. But we're now getting much earlier. But then we've got members obviously now into their 90s in terms of the requirements of and running their SMSFs. Now, it doesn't mean to say that they can't run their fund, but they may want to get some assistance in there, and therefore they have the scope to appoint someone to take over that role for them whilst they retain membership inside the SMSF.
Yeah, and look, it's not uncommon for people to go about establishing enduring powers of attorney if they're traveling or for other purposes. They might want to have their legal affairs in order to have someone be able to help them out with their I guess, various circumstances in life. What it really alludes to is, if you're having that conversation with people about becoming your enduring power of attorney, is whether they appreciate the capacity that brings for them to potentially step in your place as trustee of the self-managed superannuation fund. So it certainly takes that whole power of attorney power further, because it separates your powers from your normal powers under the EPOA to effectively the ability to come in and take on full responsibility as an SMSF trustee. And you would hope that people are having that conversation when they're talking to people about being their EPOA, but that person then is willing and able, from a definition point of view, to actually act in that capacity.
Yeah, so that they are some really important points, because it's their ability to want to do it, and then ultimately their consent to get appointed at the relevant point in time. Yeah. So it is, as I mentioned, a lot more common, I think, as people get older, that we need to make sure that we've got those sort of successor pieces in place to ensure that when they may become incapacitated, so dementia obviously is a perfect example of that, where someone can step into that role, but equally, as I said, they may still have capacity, but they just may not be confident enough in their own ability. And that might happen when you get maybe the dominant trustee has lost capacity or passed away, but the fund remains, but that surviving spouse or that other spouse that is a member of the fund just doesn't have, the whereabouts of what they need to do, may be overwhelmed by it all. And if they have, a family member or someone within there that can step into that role, then quite clearly there's nothing within the definition of Section 17A that precludes that from actually happening.
Yeah, and I want to come back to another point on that in a moment, but I'll also sort of highlight that this also talks about the beginning of life as well, and the ability to, generally when we have children under the age of 18, one, they don't have a legal personal representative. They haven't been to the courts and had someone appointed for them.
Yep.
Two, they don't have enduring powers of attorney, but they do have parents or guardians, and the same under Section 17A, it does provide for a parent or legal guardian to act in the place of a child who hasn't reached the legal age of 18. And so you may have one parent acting in multiple trustee roles if they've got multiple children in the fund. So that's another thing to contemplate. But what I will say about the enduring power of attorney is one of the key issues, and you mentioned the key word consent before, and that they have to consent to act. Well, they also have to consent to be removed as well. And so there are certainly issues to contemplate with regards to appointing somebody that isn't one of the natural members to act in place of the member of the fund, because you don't want a situation, and we've seen it before in court cases, where a separate enduring power of attorney was appointed, and then the legal personal representative on death also wanted to be appointed, but the enduring power of attorney was not willing to be removed, and it created a bit of a fight as such between effectively dueling siblings.
Yeah, absolutely. And I was literally going to go down that path myself until you took the words out of my mouth, because understanding when a role actually will stop is crucial to that process. So, that in that instance, I think might have been the Williams case, but ultimately that EPA role didn't cease. And when the legal representative came in, there was somewhat of an argument over who was entitled to the decision making, and ultimately they were both entitled to some form of decision making as a result of that judgment. So yeah, there are a number of real critical issues that we need to know, but equally, in saying that, there are some opportunities in there to assist clients with the structuring where we need to go outside the 9 dots of our 17A definition, where all members must be trustees and all trustees must be members. So Tim, thanks once again.
Always a pleasure.
Everyone, have a great rest of the week. Take care and bye for now.
Bye-bye.